Good evening. My name is David Vogel. I am back in the chair after a month away, and we are continuing our discussion tonight. If you remember, if you saw my last program, we were having a discussion with attorney David Bortz. We were discussing comprehensive immigration reform back then, and we have a second part of that discussion. We're going to move from more or less the overview of immigration reform into some common problems that are faced by people who are in this country, whether they're here legally or illegally. We have with us tonight a woman named Amy Long. She is an immigration attorney originally from East Providence, Rhode Island. She now practices in the D.C. area, right outside Washington and on the Virginia side. And she has been good enough to join us tonight and discuss some common problems. Now, anybody who's seen my show before knows that I usually don't work from notes, but because tonight is a little different, we're going to talk about specific issues, and then if she has anything to add, we'll talk about those. I've actually prepared some notes, so if I actually glance down at my notes, you'll please forgive me. Amy, welcome.
Hi, David. Thank you for having me.
No problem. Why don't you, before we start, I just mentioned that you're a native Rhode Islander, but if you've got anything you want to say to the state, say to your home state, go ahead and say hi, and welcome back, by the way. I know you just got into town a couple of days ago. And tell us how long you've been gone. And
thank you very much. I originally left Rhode Island right after I graduated from college. I moved to the Washington, D.C. area, so I've been there now for about 14 years or so. I come back several times per year to visit, and I'm very happy to be here. I have warm feelings toward my home state of Rhode Island, so I'm always happy to come back to visit.
Wonderful. We're thrilled to have you. Let's get into it really quickly. You've been practicing immigration law for several years. You're a solo practitioner, right?
That's correct.
Okay. And I'm sure that you've seen a whole bunch of stuff that maybe the average person doesn't see in life, but I mean, I get calls, and I sometimes do know what to do, and occasionally have to do some extra research, but we're going to draw on your expertise tonight because I'm not the expert here. So let's start. As I said, I had prepared some notes, and let's start with some common problems. And first up on my list, let's say we've got a person holding a green card, okay? The person's from Mexico and would now like to petition for a brother or a sister, a sibling, and wants to bring their sibling to the United States. Talk about kind of the process on that and some of the pitfalls and some of the issues that person might be facing.
Well, if a U.S. citizen wants to petition for a sibling, the first thing to keep in mind is that that particular category has a particularly long wait. It's considered a fourth preference of the family-based preference categories, and the wait time is presently about 11 and a half years. The last time I checked in the Department of State Visa Bulletin, which is published every month.
Okay.
There are 4 countries that are the exception to that wait time, and I believe they are the Philippines, India, China, and Mexico.
Yeah.
So that actually speaks to your hypothetical.
That's why I did it that way.
The wait is a little bit longer in those countries. I think for Mexico, it's actually closer to 17 years. I think we had discussed that earlier. So that's one thing to keep in mind, is that is actually a long wait time. So your U.S. citizen petitioner is going to want to file a petition in the United States, and once it's approved, it's going to make its way through the Department of State and eventually to the embassy, but it's not going to make its way there until the person's priority date is current.
What's a priority date?
The petition that establishes the relationship, it's actually called a Form I-130. That petition, the government establishes a priority date with the filing of that petition. So it's generally the same day that it's filed as the date that the priority date is established.
Okay, so I file the I-130, so that date now becomes kind of a lock-in date, if you will?
That's right, exactly. And the receipt notice is going to state the priority date. There's actually going to be a box that says priority date, and it's going to have your priority date. So you have to wait until the priority date becomes what we call current before a visa becomes available, and the person will then apply for the visa at the embassy.
So the currency of the date, in other words, they have to work through the backlog, is what you're saying?
Exactly.
And that could take as you said, 7, 11, 17, 20
exactly.
years in some cases.
The sibling preference category is actually one of the longest waits.
So why would somebody want to go that route? I mean, not to get inside the head of somebody, but if people hear that, I mean, in your practice, if somebody hears that, do they get turned off to the idea? Do you still see people wanting to go through with it?
Very often they do. What I would do as a practitioner is I would work with the client to see whether or not they have any other options. Okay. In some cases, it may be that that's their only option, is to have a sibling petition for them. Okay. So if that's the case, I will often tell the client, I'll say, file the petition. The time goes by a lot faster than you may realize, but every journey begins with the first step. So the first step is to get that petition filed. And then the wait times fluctuate in the category. Sometimes it can be 10 years or 9 years. And right now it's a little bit longer than usual. It's about 11 and a half.
You mentioned other options. I mean, for instance, somebody comes into your office and you look at it on the surface and you say to yourself, well, okay, it's going to be a 15-year wait time. What kind of options would you discuss with somebody? I mean, are there other avenues for family petitioning? Is there a different route? Do you tell them to come in iwi? I mean, how do you do that?
Right. And iwi, of course, is entering without inspection. Right. What I do is I evaluate their immigration history. We talk a little bit about their family, whether or not there's any other qualifying relatives who could petition for them. Do they have a spouse? Do they have a child? Of course, we talked about a sibling, a brother or sister. So those are the main questions that I would ask. Is I would review their immigration history to see whether or not there were any options, and also to see whether or not there are any obstacles, so that when their priority date does become current, that they would be admissible to the United States.
Let's talk about that for a minute, admissibility issues, and that's going to come up in some of the other questions. Explain to the audience what is the meaning of admissibility, because I think there might be a misconception out there. Some people don't understand the difference between admissibility and an admission, or an exclusion, or an excludability. Just kind of talk about that for a minute.
Well, when you're applying for your green card, you're applying for an admission to the United States, and that applies regardless of where you're located. It's really an interesting concept. So even if you're located in the United States and you're applying for a green card, you're still applying for an admission. Mm-hmm. So that's the first thing to keep in mind.
That's even if you're in the U.S., you said?
Yes, even if you're in the United States. Whether you're outside the United States or inside the United States, you're applying for an admission when you're applying for your green card. And as such, you are subject to what's called grounds of admissibility. You have to be admissible to the United States. Mm-hmm. There are many grounds of admissibility. You have to show that you would not become a public charge. You have to meet medical grounds of admissibility. You may not have committed any certain crimes which would make you subject to inadmissibility. Mm-hmm. So that's basically how that works.
Okay, and so you have to basically go through the checklist and be clean and acceptable.
Oh, yes, okay. Exactly.
And okay, let's go on to the second question here. This one actually I kind of came across myself, and let's see how you would handle it. A U.S. citizen called me up, and she said, look, I'm a U.S. citizen. I have a fiance who is here on something called the Visa Waiver Program, and I will actually allow you to explain what a Visa Waiver Program is. She said, I want to get married 2 days ago. I want the paperwork to be done yesterday. What do I do? Go.
Okay, well, that presents a lot of different issues. If they entered on the Visa Waiver Program and they are married to a U.S. citizen, they are allowed to adjust status. However, if for some reason they are found inadmissible, or if something goes wrong in the process and they're put in removal proceedings, the only form of relief that's available to them is a possible asylum claim. There's another big issue that comes up here. If they entered on the Visa Waiver Program, it's important to look at how they represented themselves at the time that they entered the country. They need to be very honest at the border and say, hey, I'm here to get married, if that should have been the case. And they have to run the risk that the Customs and Border Patrol officer may turn them away and say, hey, there's a process for that. It's called a fiancé petition. You need to go back home. But they have to run that risk, because if they don't, then when they go to apply for their green card, they could be accused of having made a misrepresentation deportation at the border. So it's just a risk that they have to take. So it's not something I would normally recommend, is for someone to enter the United States on the visa waiver program in order to get married.
And I was going to get there. Explain if you can what the visa waiver program is versus, I mean, I'm not a fan of the visa waiver program. I don't like it. I don't really think it's a visa waiver. I call it an electronic visa. But explain the difference. How would your answer change if the person was here on, let's say, a regular, normal B1, B2 visa that's good for several years, and the person has an I-94, let's say, where they were in this country for 3 or 4 months or something like that, and now they've got a much longer period of time. How does that change your answer, if at all?
Well, my answer is actually pretty much similar.
Okay.
If they misrepresented themselves when they were applying for the visa, and then they acted contrary to their intent within a short period of time of entering the United States, then that's something that may be problematic in the eyes of the government later on when they apply for a green card.
Okay. Okay, good. But does it change the answer at all with respect to removability? My understanding of visa waiver is that you have no grounds for contesting removal.
That's right.
Versus if you're on a B1, B2, you might have a chance. Is that correct?
That's right.
Okay.
Yeah, the visa waiver program, you had asked earlier a little bit about that. The U.S. government has selected certain countries to participate in the visa waiver program. That is to say that you can enter the United States without a visa. There's still a process. There's a program called ESTA where you do some online registration to show that your intent to use the program.
Okay. Now, one other question that it's kind of a sub-question to this. Talk a little bit about marriage fraud. I mean, one of the things I guess is pretty common for the USCIS to see is somebody enters the United States, let's say on a B1, B2, or some other sort of tourist visa, maybe even visa waiver. And they're here specifically to find a spouse, and they don't care how they do it. Talk about marriage fraud and how prevalent it is. Do you see it in your practice?
Marriage fraud, David, actually is a huge issue. Okay. The government is constantly on the lookout for fraud. And anyone who enters the United States with the intent to overstay their visa, to marry a U.S. citizen, and to perpetuate a fraud is going to get caught and needs to be discouraged from doing that. In the words of the government, they have entered into the relationship for the purpose of evading the immigration laws. And it is very much not a good idea.
No, I didn't think it would be a good idea. I wanted you to talk about it a little bit because I know it's a problem. All right. My parents came to this country illegally when I was a baby. I was brought here. I'm now 20 years old. Okay. I'd like to get a job. I did my high schooling, maybe did a junior college or something. I want to get a job. I want to take my place in society. No criminal record, okay? I've never had documentation. What can I do?
That's a very unfortunate situation that person is in because they've entered without inspection. And there is some legislation that was introduced a while ago called the DREAM Act. There are state DREAM Acts, there's a federal DREAM Act that was contemplated, but it never came to pass. And it would have helped someone like this, someone who entered the United States without inspection, when they were too young to have had a say in the matter, and would have given them a process or a path through which they could have eventually obtained a green card. Now, keep in mind that these are young people who all they know is the United States. They don't remember their home country. So advocates of the DREAM Act would say that these are people who certainly should have the opportunity to have a path carved out for them. People who have done well in school, people who have maybe performed military service, and who become a conditional permanent resident. There are different forms of the DREAM Act that have been introduced. There's no final bill yet. Unfortunately, we haven't gotten that far yet. But so in your hypothetical, this is someone who would not have many options open to them. Now, if you don't mind my digressing for a minute.
Not at all.
About entering without inspection.
Digress away.
If you've entered without inspection, your options for getting your status corrected are limited. That's one of the more difficult positions for someone to be in, is someone who has entered without inspection. Generally speaking, if you have someone who's able to petition for you, a qualifying relative who's able to petition petition for you, but you've entered without inspection.
Explain a qualifying relative real quick.
Okay, well, under the immigration laws, if you have someone who's able to petition for you, then you can file then that person would file a petition on your behalf for your green card. But it's only certain relationships that are recognized, such as a parent, a spouse, a sibling, or a child.
And as I understand it, there are limitations even within those categories.
That's right. That's right. So it wouldn't be a cousin, an aunt or an uncle, a niece or a nephew. Those are not qualifying relatives.
And there are some age restrictions too.
There are some age restrictions.
One of my favorite pet peeves, and maybe you can talk about this, I don't like the term anchor baby. A lot of people talk about anchor babies, and I say, but you have to wait 21 years for that person to be an anchor baby.
Right. It actually gets very complicated. Some people would say that why should we give status to someone who's entered without inspection? Why should we give them this benefit? And then they're going to be able to petition for their relatives. Well, it's actually much more complicated than that. If they entered without inspection, they're going to have to go back to their home country. If they've accrued what we call unlawful presence, they're going to need a waiver. They're not even eligible for the waiver unless they have a qualifying relative. Now, this is a qualifying relative in a different sense.
Okay.
This is a qualifying relative for waiver purposes. So you have to make a showing of extreme hardship, that qualifying relative would experience extreme hardship if the beneficiary or the applicant were not allowed back into the United States.
Okay. And that's a pretty high standard, I guess.
It's a lot of work from the practitioner's point of view, and there's a certain amount of risk that's involved.
And you were actually explaining to me before we came on the air that there's a proposal by the government to actually modify the waiver program.
That's right. Yep.
Can you talk about that a little bit?
Sure. It's called a provisional waiver.
Mm-hmm.
It has not been implemented yet, and it's very important that your viewers understand that this is not the current law.
Okay.
But this is a proposed law that applicants who need a waiver for unlawful presence would be able to apply for that waiver after they have an approved petition, an approved I-130. Mm-hmm. They would be able to apply for that waiver while they're in the United States. If it's approved, then they leave the United States, come back in through the embassy in their home country, mm-hmm. but this time they have an approved waiver, so they're in a better position of strength as opposed to the way the law is currently, and that is that they're outside the United States and they apply for a waiver and they don't even know whether or not the waiver's been approved.
Okay, so it gives you a little bit of leeway, I guess, or a little bit more time in this country to kind of straighten things out. Mm-hmm. The other side of that coin, though, is, and we discussed this, you've now disclosed to the government, hey, I'm not here legally.
That's exactly right,
and so
David.
what would the government do in the 601A case where, okay, you've now applied for the 601A in good faith, mm-hmm. and somehow you got denied? They're just going to put you into deportation? I mean, so what's the incentive to actually go through this?
Well, a lot of this involves a certain amount of risk. Mm-hmm. So the applicant needs to be fully informed of the risks. Mm-hmm. There's no guarantee that they're going to be permitted back into the United States. The consular officer has to grant the visa. It's a discretionary decision. And, even though they have the approved waiver, there's no guarantee that the person's going to be admitted back in. So the applicant has to leave the United States willing to take that risk. Now, the intent of the government in introducing the provisional waiver is to keep families together, is family reunification, particularly for a category that's called immediate relatives. Mm-hmm. There are 4 preference categories, and the first one is immediate relatives, and there's no wait time other than the time to process the petition. And those are categories that the government considers close relationships in its effort to promote family reunification. And that's one of the government's motivations in introducing the provisional waiver.
Good. Okay, let's move on. We actually only have not too many minutes left. Somewhat variation on the last question. Let's say it's the same facts. My parents came to this country, came illegally. I've been here illegally, accrued unlawful presence. And in order to get jobs, I did some things that maybe I shouldn't have. I claimed that I was a United States citizen because, again, I've only known this country since I was 2 years old. Does that put me in a much worse position, same position? How can I correct that, if at all?
Well, there's a couple of issues there. If they entered without inspection, they'll have problems getting their status straightened, as we talked about. They would be subject to consular processing. However, if there's the added issue that you mentioned of making a claim to U.S. citizenship, what we call a false claim to U.S. citizenship, that would also pose problems in their admissibility. Mm-hmm. They could be accused of having made a misrepresentation. This is something that's taken very, very seriously, making a false claim to U.S. citizenship.
And how does one go about making the false claim? I mean, just to stand there and say I'm a U.S. citizen, or do they have to sign a document? Do they have to do something?
Well, there are a lot of ways that someone could potentially be accused of having made a false claim to U.S. citizenship. They could have been asked point blank in an interview by a consular officer or a Customs or Border Patrol officer, are you a U.S. citizen? And when you take into consideration potential language barriers, mm-hmm. The nervousness of the person at that moment, they may have accidentally said yes. Another way that this issue can come up is in the I-9 process. When someone is applying,
they get a job.
Exactly. When someone is applying for a job in the United States, as you're aware, they fill out a form called an I-9 proving that they have authorization to accept employment in the United States. Well, one of the boxes that they would check off is, I'm a citizen of the United States, I'm a national of the United States, I'm a lawful permanent resident of the United States. Well, if they've checked off that they're a citizen when they're not, they could potentially be accused of having made a false claim to U.S. citizenship.
And that would be a problem even if they had come in legally, right? I mean,
yes.
If somebody came here legally and maybe even had a green card, I mean, they're still not a citizen, correct?
That's right.
So
yep,
if they check that box, that could get you into the same kind of problem.
Yes, it could. It could get you into hot water, so to speak, at both stages, when you're applying for a green card or when you're applying to become a naturalized U.S. citizen.
Okay, let's move on to a slightly different question, and this is one that actually comes up a lot. I've seen it several times. I'm sure you've seen it more than a few times. I'm a green card holder, and I've been a green card holder for a number of years, but I haven't been able to file my application for citizenship because I've had some criminal trouble, okay? And maybe the criminal trouble has been some harsh misdemeanors, maybe it's been some drug issues, maybe it's been a couple of other felonies. Talk for a few minutes about what kinds of criminal matters, even for green card holders, will become huge problems for you as you try to move towards that citizenship, and what kinds of obstacles you face, and maybe even the ultimate obstacle, which is deportation and permanent bar from the United States. What kinds of things will get you into trouble there?
That's a great question, David. One of the more serious crimes that you could commit is a crime involving a controlled substance violation, especially one that does not involve possession of marijuana, 30 grams or less. So what you're dealing with is, with someone who has a green card, they could potentially be subject to deportation, as you mentioned. Another issue is when someone is applying to become a naturalized U.S. citizen, they have to show that they possess good moral character, and that they have possessed good moral character for the 5 years or 3 years, if their application is based on marriage to a U.S. citizen, preceding the filing of the naturalization application.
So that if they get into trouble, it kind of pushes that timeline out, I guess.
That's right. A practitioner may analyze the case and say, hey, maybe you need to wait a little bit more time before we go ahead with filing the naturalization application, or let's counterbalance these mistakes that you've made with evidence of good acts and good moral character.
Now, where do you draw the line? I mean, when somebody comes to you, what kinds of offenses do you look at and say, you throw your hands up and you say, I can't help you. I just can't help you now.
Well, certainly if someone has a conviction which is going to subject them to deportation, then we would not move forward.
What would that be? I mean, I know that there's crime of moral turpitude, and then there's the drug offenses, but aggravated felonies. Talk about what kinds of things that maybe in the public's mind you wouldn't actually think is going to be something that's going to get you tossed. And you actually raised a great point. You told me about a case that you had in Virginia, and you ended up being a victim of bad state law. Talk about that for a minute. It was a real surprise to me.
Right, right. There is a ground of deportation that says if you've committed a crime of moral turpitude within 5 years of a lawful admission for which the potential sentence for that crime under state law was 1 year in prison or more, then you are subject to deportation. So you have to look at the state statute for that particular crime. Well, in Virginia, a petty larceny is considered a Class 1 misdemeanor, for which the potential sentence under state statute happens to be 1 year. So unfortunately, that has happened. I've had clients that that's happened to. You and I talked about that, where if you have committed a fairly small crime, a petty larceny, it's somewhat of a small, a small offense. You could be potentially subject to deportation, even if you've been in the United States for many years. And this is something that eludes many people that I want to draw people's attention to, and that is that even if you are a lawful permanent resident, no matter how long you have had your green card, you are still subject to the deportation laws, which is another incentive to become a naturalized U.S. citizen.
And yet, a lot of people end up staying here for a long time and just don't. I've never understood it. Okay. We're just about out of time, and I'll give you the last few minutes. There were a couple of things that you wanted to talk to the general public about, and I'll let you kind of talk about your own, some of your experiences and maybe some advice you might have for people out there. So I'll let you have these last couple of minutes. I'm not going to talk.
Okay, great. Thanks,
or if you want me to talk, I can. But you see, you've got a pretty good handle on things. So go ahead, talk to the public.
Jump in if you need to.
You're a Rhode Islander. Come on, you know the people here.
Well, one piece of advice that I'd like to impart on the public is that if you have encountered an arrest and you are facing a potential conviction, you need to seek the advice of a criminal defense attorney, but not just any criminal defense attorney. You really need to seek out someone who either practices both immigration law and criminal defense, or a criminal defense attorney who has a close collaboration with an immigration lawyer. This is very important. There are many criminal defense attorneys out there who do not know immigration law, and they proceed with a guilty plea, or they do not know how to protect their client from the immigration consequences of the conviction. So that is one thing that I really want to point out to people.
A great case for some generalism there, I suppose. I mean, I saw that too. I told you, I think I had a call from Connecticut where the person had been a green card holder for about 10 years and got himself into some trouble. He was dealing in drugs, and I don't know what's going to happen to him, actually, because I didn't get hired there. Well, we are almost out of time, and I want to thank you very, very much for coming in. This has been a delight, actually.
It was my pleasure. Thank you for having me.
Thank you.